on this side of the law, on that side of
Well, hello. Welcome, everyone, to another segment of Law Talk, an informative podcast where your answers to legal questions are attempted to be answered by us. I'm Mark, the attorney Judson.
Jonathan, Law Dawg, Fondo from the marshes of Camberpier.
And to the courtrooms of Calcasieu, this is Law Talk, an informative podcast trying to bring pragmatic answers to pragmatic legal questions. Today's topic, successions. Law Dawg, what's a succession?
Succession, my words matter when it comes to successions, and it sucks to not succeed at successions. Successions is when
Could have been said better myself.
a person passes away. How do you get the land, mostly land is the biggest issue, or the vehicle, or the bank accounts, or the stocks and bonds, actually transferred?
The ownership.
The ownership. You can have possession of those things, but you can't sell, buy, lease, whatever. A succession is what you do where at the end of all the paperwork that you file, you have a judgment. And this judgment says, I hereby order you that the tract of land that belonged to Papa Bear now belongs to Papa Jr. And then the assessor actually gets in the computer, changes the name from your grandfather's name to your name.
And that judgment is called a
Judgment of possession.
judgment. So that's the final document that you're looking for in this.
And that you take to the bank, you take to the DMV, or you take, of course, to the assessor's office, or they get a copy. But to do that, you have to have a series, you have to follow a bunch of things that contain the information. First of all, that the person died, will or no will. Because if they don't do the will, the state law takes over. Unlike some people think property didn't go to the state, but it goes the way the state says it's going to go. First to your heir and descendants, and then sideways, and then upwards, and eventually, usually find somebody. If you have a will, it has to be probated, which means proved. It has to be proved that it's authentic. It's got to follow the record, and then you do with the wishes of the testator. I want so-and-so to get my couch. I want so-and-so to get my vehicle, and my land goes this way. You also have to have some sworn affidavits. Yes, I knew this person. Yes, they passed away. Yes, they didn't have any other children or adopted no one.
So, Law Dawg, sounds like a lot of paperwork and stuff. Is it a good idea to try to do this by yourself?
It's rare because as you know, in Louisiana, forms matter a lot, and you can't just Google them off the internet. You can use an old succession, but they almost always need a lawyer. Now, there is something if there's not much property, you can do a small succession, which is basically an affidavit that just has to be notarized. But that's only at a certain amount it has to be below. And still, you may want to buy a little bit of lawyer's time just to get some guidance on it and have them check it out before you fill it out.
That magic amount happens to be $125,000.
It's now up to $125,000.
It's $125,000. If the decedent owned no more than $125,000, you can avoid all that process that Law Dawg was talking about and go to a small succession affidavit, which is faster and cheaper. Still probably need the guidance of a lawyer.
I'm so old. I can remember when a small succession was $75,000 or $80,000, something like that. But anyway,
$125,000.
But when you file the petition to put everybody in possession, it's called a petition for possession. Imagine that. But that's what people usually refer to when you open a succession. The initial filing is a petition. You still might need to gather people's, let them know, you have some property, are you accepting, because you don't have to accept. If somebody has a succession and they have a bunch of debts, and the debts is more than the property, you don't have to accept it. It's called what? Renunciation?
Yes, you could renounce these successions.
Renunciation. I don't want.
So you're raising the question: are the heirs responsible for the decedent's debts?
The heirs are. It's very common to say the heirs are not responsible for the decedent's debt. However, I think people need to be told that you also can't have any of the property.
Right.
You can't take just
only if you inherit the property. Right. If you take the property, then the property, you have to pay the debts up to the value of the property. Let me ask you this, Law Dawg. For the average person, there's a lot of process involved. What can people do to prepare to go visit an attorney about opening a succession when that loved one dies?
Of course, when you're dealing with real estate, he told me and I said, and they said, it's worthless. If there's any documents, find the documents, find the wills, oral promises when it comes to land are worthless. And of course, if you have any actual documents that show the legal description of the land. How did your grandfather, father, mother get the land?
Bring, for example, is there a will?
Is there a will?
Is maybe a death certificate? If you have a death certificate, it'd be very helpful. Maybe if there is no will, can we have a deed or some other type of document by which the decedent obtained the ownership of the land?
And
maybe a car title. Then a car title.
Car title, all the titles.
Maybe accounting for.
If you know who the heirs are, then you need to be able to identify them and find an address, because they need to be noticed about the succession. They may have some interest in the property, you may not want it, but they have to be noticed. You don't want your lawyer to, charge you $300 to go track everybody down. You can do that legwork yourself. You need to come with the information about what they owned, was there a will or not, and who is going to get what.
Who are the heirs?
Who are the heirs?
Who are the children? Do they have children? Were they married? So many times.
If they died before their children will be representatives. So who are those children, and where can they be found?
And of course, many attorneys will guide their clients with the information they need with the form of. Any other information you want to pass on to the listeners about the succession process before we wrap up this episode?
Successions are almost always necessary because people stay on ancestral land for generations, and they can't ever own it, which is, the intent of your heirs, of your ancestors. So the successions pile up, and they never get done, and the people never own the land. So open a succession, have them done as soon as you can, and then you can't really rush them because it's a lot of information and has to be meticulous. But that's what opening a succession does. It starts the process, whereas you can become the owner, or the heir can become the owner of the property of somebody who's deceased.
In Louisiana, the way you transfer assets from the deceased to the deceased heirs or legatees is the succession process.
Clarence Darrow couldn't have said it better himself.
For Jonathan the Law Dawg Fontenot, I'm Mark the Attorney Judson, thanking you for tuning in to this edition of Law Talk. If you have questions, contact us at the information that will appear on your screen. That's Law Talk, bringing common answers to common questions. Thanks for tuning in.